Welcome to today's program titled California Employment Legislative Update. At this time, all participants are in a listen-only mode. For those of you who are logged into the live web presentation, you are encouraged to submit questions throughout the conference by typing them into a Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down as it will not be reread and is required on the CLE credit request form. During this program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of this webinar recording and materials should be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion or any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Christina Lawney. Christina, please go ahead.
All right, thank you. Welcome, everybody. Good morning or afternoon, wherever you may be. We are here to talk about what happened in this California legislative session with respect to employment laws. I'm a partner up in Sacramento, and with me is Kathy Feldman down in LA. And we're excited to be with you today. So we'll move right into it. We're going to start with just a review of the year in review to remind you what happened throughout the legislative session and a couple of statistics about what happened at year end, a couple of new laws having to do with discrimination and harassment prevention, then some changes in leave laws, then a little bit of WARN rehiring and wage and hour law changes, some changes to record keeping requirements and some civil litigation provisions. And then finally, just a quick note about a couple of vetoed bills that will probably come back and that had some interesting veto messages by the governor. It was overall a fairly light year compared to years in the past. And as you'll see on the statistics on the next slide, or at the slide after that, but on this one first is our year in review. So as you can see, the legislature made it through each of these dates. We will be tracking the new legislative calendar once the legislature reconvenes on December 7th for the second year of the two-year session. But ultimately, as you can see from the January 1st, 2026 date there, that is when all of the bills that we are going to be talking about today that the governor signed into law will become effective with exceptions as noted, just a few exceptions that are both in our blogist bills and to bills we may talk about today that may have had an urgency clause, meaning they went into effect immediately. So as to the statistics, the 2025 legislation by the numbers, just, a little bit of points of interest here. So the governor had until the end of the day on October 13th because the legislature adjourned late this year, a day late. So the governor had an extra day into the calendar, really the same amount of time to consider bills that passed to him as he would have had. He took action on 917 bills. That's down from about 1,200 bills that got to his desk in 2024. That marked the highest number of bills that reached the governor's desk during his tenure as governor. He acted on every one of those 917 bills that landed on his desk, and he's done that every year of his 7 years in office. He didn't just, let bills that he either didn't approve or veto die by virtue of that. And so in total, he's acted on over 6,600 bills. He signed or approved 794 of those 917 bills this year. And that again was down from his just over 1,000 bills that he approved in 2024. And he vetoed 123 bills this year. That was about a 13.5% veto rate, which is obviously lower than the 15% average historical veto rate over about the past 40 years. We do not crunch those numbers. We give credit to all these numbers to Chris McKelly, who's a lobbyist and legislative, really historian and watcher and professor here in Sacramento. So to dive in to the first of our bills, Kathy.
Thanks so much, Christina. So we are going to tackle the very first topic we're going to tackle is pay equity. And we're seeing a landscape on a federal basis where there's broadening pay gaps from between genders, but that is not the case in California. And our legislation certainly keeps taking steps to increase the equitable pay standards for employees. So first, we've got SB 642. And this bill did a whole bunch of things. First and foremost, it revised the pay scale definition. And now the standard is that there has to be a good faith estimate of the salary or hourly range that the employer reasonably expects to pay for the position upon hire. And this might not sound like such a big change, but we anticipate that it could narrow the posted pay scale because the range should be the range that the employer expects to pay the candidate upon hire instead of broader ranges that some employers might have previously been using to cover an entire range for any one position. The amendments also confirm that the definition of wages for equal pay claims aligns with the Federal Equal Pay Act. And that means that it includes all forms of compensation, including benefits such as life insurance, vacation pay, holiday pay, stock options, and bonuses. And as you all know, some of those categories can make up a significant portion of wages depending on position and sector. Despite that clarification in the equal pay context, there's no requirement that employers include additional forms of compensation in the posted pay ranges. So that's something to also keep in mind. Another thing that SB 642 did was it extended the statute of limitations for civil actions to recover wages by 1 year. So now there is a 3-year statute of limitation from the last discriminatory pay act or alleged discriminatory pay act. But plaintiffs are allowed to seek relief for an entire 6-year look back period. So 2 different timeframes to keep in mind there, but both greater than they were before. There's also been an expansion under this bill of the prohibition against sex discrimination to prohibit paying employees of another race for performing substantially similar work. And that word "another" is really critical here because it replaces the previous use of opposite sex. And so it's removing a binary gender reference and making the language more inclusive. And we might see some kind of more assessment and analysis of that depending on how equal pay claims progress under this amendment. There are also some clarifications on when a cause of action arises under SB 642. And that's going to be anytime an alleged unlawful compensation decision or other practice is adopted, if an individual becomes subject to an alleged unlawful compensation decision or other practice, or when an individual is affected by application of an alleged unlawful compensation decision or other practice. So a whole host of things under just 642. And then we also have SB 464, which has some significant changes as well, not quite as many as 642. Under 464, there's a clarification that any demographic information gathered by employers or labor contractors for the purpose of submitting full data reports must be stored separately from persons' records. And the demographic information that might be collected for purposes of compliance includes any information related to race, ethnicity, or gender. There are also going to be new reporting categories for pay data reports, but those are not effective until January 1st, 2027. So that is after the next pay data reports will need to be submitted, which is in May of 2026. A little bit more bandwidth and time, before those new pay categories those job categories go into effect. But when they do, they're increasing from 10 categories to 23 categories. That question that maybe some people are having difficulty hearing. I'm not sure if that's isolated or for everybody on the phone. But we'll move ahead to AB 250. So out of our pay equity landscape, AB 250 is extending the statute of limitations for sexual assault and harassment claims. This is an interesting one. It's extending. I'm sorry, I'm seeing another question that people are having difficulty hearing me. Christina, is it clear on your end?
Your sound is going in and out a little bit, Kathy.
Okay, let me see if I can do anything about that. Certainly want to make sure everyone is able to hear all of the information that we're covering. Christina, do you want to tackle this slide and I'll see if I can solve audio on my
Yeah,
end?
sure. That sounds great. So I'll take over here. So AB 250 extends the period within which claims for damages suffered due to an alleged sexual assault, which would otherwise be barred prior to January 1st, 2026, under expiration of the statute of limitations. It would revive those claims, and it also revives derivative claims for wrongful termination and sexual harassment deriving from the alleged sexual assault. To revive the statute of limitations, the plaintiff must demonstrate that one or more of the entities legally responsible for the damages engaged in a cover-up. So it doesn't just extend the statute of limitations, it provides essentially an exception for if you're learning about this, you get extra time because one of the entities actively tried to cover up the fact that you might have a claim for damages here. The claims may also proceed if they may proceed if they were already pending in court on January 1st, 2026, or if commenced between January 1st, 2026 and December 31st, 2027. So from an employer perspective, obviously, the takeaway here is to just know that where you might have thought that something was time barred that falls into one of these categories, wrongful termination, sexual harassment deriving from alleged sexual assault, they might get extra time to bring those claims. Okay, SB 303. I'll handle this one and then we'll see if Kathy can jump back in with her sound. This one is really encouraging employers and employees to do the right thing and make sure that they get bias training, bias testing. It provides that an employee's assessment, testing, admission, or even acknowledgement of their own personal bias that is made in good faith and that is solicited or required as part of bias mitigation training does not constitute unlawful discrimination under the FEHA. You want people to acknowledge that they might have some inherent biases. We all do, right? And be able to learn from that and not worry that it could then be used against them or cause them to be accused of unlawful discrimination. In the next bill, Kathy. Oh, leave laws, good, because Kathy is our expert in leave laws here. You want her to be talking about these.
Hopefully everyone can hear me now. Always,
Better.
On our toes with technical difficulties during these webinars, but we can move to the next slide and get into the meat of this. So AB 406 is a fun one for some if you really love parsing confusing statutory text. This one certainly has a lot of that. And on its face, it seems like it does a whole lot. But really the changes that it's making are a lot more background change and will possibly lead to some consideration of, how we group different protections for employees together, if that allows us to streamline some policies. And some of that we're going to tackle in a lot more detail during our handbook webinar, which is coming up on October 29th. So what we're going to talk about on this category today is a little bit of a preview and dipping our toes in to some of those bigger topics that are really ripe for discussion during that webinar. So if you're interested in how policies might be impacted by some of these and other legislative updates, please join us on October 29th. For today, what we'll talk about here is that beginning on January 1st, 2026, there's an expanded reason for use for sick leave as well as unpaid job protected leave. And that is when an employee or a covered family member are a victim of certain crimes and are attending judicial proceedings related to that crime. Now, for those of you who joined us on the webinar last year or are familiar with some of the amendments that went into place in 2025, this might sound like it's not such a big change because last year we had another amendment to paid sick leave law that dealt with victims of qualifying acts of violence. And the wording here sounds pretty similar to that amendment, but there are some subtle differences, including what qualifies as a crime and also who qualifies as a victim. It's a different definition there as well. So again, a lot of that stuff that's going to impact your policy language and some changes there. As I mentioned, this doesn't only impact sick leave. Employees can use any compensated time off for this category of leave, as well as unpaid time off as well. Another thing that sort of tracks along with amendments that happened last year in 2025 in the last legislative session, there was a move from having these types of leave provisions enforced by the DLSC and housed under the labor code. And they were moved to the government code and enforced by the Civil Rights Department. It seems that some people felt like that maybe jumped the gun a little bit. And so they are moving some reinstatement. They're reinstating some provisions back under the DLSC's authority, but for a relatively brief period of time. So you'll see on the slide here, we talk about that it's only for alleged actions occurring up to December 31st, 2024. That's only worth noting to the extent that if you have an employee who brings a claim regarding sick leave that they were not provided or other compensated time off that they weren't provided, to keep in mind that that's currently, if it occurred up through December 31st, 2024, a cause of action under the labor code. And so subject to potential PAGA claims or the like. However, when these claims were previously housed under the labor code, PAGA claims related to unpaid sick leave, I think barely if ever happened. So, limited risk there, particularly given that December 31st, 2024 is almost a year behind us. We can move to the next slide. All right, another leave-related change. Beginning on July 1st of 2028, paid family leave benefit eligibility is going to expand to include individuals who take time off to care for a seriously ill designated person. In California, we are very familiar with that term designated person. We see it crop up in a few different contexts already, including SIFRA and for sick leave covered uses. So this is a little bit of an expansion to bring it more in alignment, particularly with that SIFRA definition of designated person. There's some alignment between the two here. So that's going to do it for our leave-related changes this year. Relatively a light lift compared to what we've seen in prior years. And I'll pass it back to Christina to talk about some other fun WARN and wage and hour stuff.
All right, thanks, Kathy. And really, I was happy that I didn't get those and happy that I'm not giving the handbook webinar that Chelsea Mesa, lead of our handbook team, or Chelsea Hoffman, excuse me, and Kathy and others are leading up, because the leave law changes these years, as well as the pay equity changes, are really the meatiest of what we're going to talk about today, with one exception that I'll get to in a minute. So I'm going to go pretty quickly through the WARN and wage hour changes because they aren't, to be honest, as significant as we've seen in this space in prior years. The first one, SB 617, amends the California Worker Adjustment and Retraining Act, aka CalWARN, to require employers include certain things in the WARN notices. And for those of you who are not familiar with WARN, it is kind of a specialty thing that luckily, when times are good, does not come up a whole lot. But when you are laying off employees in a group, you do need to know about the federal WARN and CalWARN. So what CalWARN does is it prohibits an employer with 75 or more full-time and part-time employees from ordering a mass layoff, relocation, or termination at a covered establishment, which is a term of art under the law, unless a certain amount of time before the order goes into effect, the employer gives written notice that has specific information in it. So amongst the information that the statute requires to be provided to employees subject to these actions will now need to be included whether the employer plans to coordinate services through the local workforce development board or another entity or not at all. And then information about CalFresh, a statewide food assistance program, and a couple of other smaller things as well. But those are the two main new additions to the CalWARN notice. The next change that'll come January 1st, or really an extension of something that's already going on, dealing with essentially hiring, laying off, rehiring, retention, et cetera, is a really follow on an extension of existing legislation. The history behind AB 58 is that it's following on the heels of SB 93 from 2021, enacted during COVID to make sure that employees who lost their jobs for COVID-related reasons in certain industries, hotels, private clubs, event centers, airport hospitality operations, airport service providers, building services, really those who no longer had work once everybody was staying at home, that they would have rehire rights after being laid off. That was expanded and extended by SB 723 of 2023. And now again with AB 858, it is extending these protections again to January 1st, 2027 from the current December 31st, 2025 expiration date. It will also allow the Department of Labor Standards Enforcement to enforce violations occurring before December 31st, 2026 to be enforced after the sunset date of January 1st, 2027. Moving on to our wage and hour legislations. The first one is getting at the continued perception that employers are stealing tips from employees, and SB 648 gets at that. It authorizes the Labor Commissioner to investigate and issue a citation or file a civil action for any gratuities that are taken or withheld by an employer from employees. The second wage hour bill here, SB 261, it states that employers who do not satisfy wage awards against them within 180 days will be, as of January 1st, subject to the following measures. Those measures include a public posting by the Labor Commissioner of the unsatisfied award against the employer on its website, public shaming there. The employer will also be subject to a civil penalty of not more than 3 times the amount of the outstanding judgment. And the prevailing judgment creditor in an action may enforce the payment of the judgment to recover reasonable attorney's fees and costs. The employer can seek to have the penalty amount reduced by a showing of good cause by clear and convincing evidence. And if there is any court-assessed civil penalty, it goes half to the employee or employees and half to the Department of Labor Standards Enforcement. So the moral of the story there is if you have a wage award issued against you, just pay it or seek other action to have it stayed while you contest it. So you're not subject to these measures here. AB 692, this is my note about the one exception, the stay or pay employment contract prohibitions. So this one is really interesting in the history, I think, and it seems to focus on 3 main industries, despite the fact that its provisions aren't made to be industry specific. We did have a couple of industry specific bills that Kathy will talk about, but for this one here, it doesn't apply by its language to a specific industry. What the new legislation will do is it will make void any employment contracts entered into on or after January 1st, 2026 that require the worker to repay to the employer a debt if the worker's employment or work relationship terminates. So there are some exceptions for this, and I'll go into some of the background behind it in a minute, but first the key provisions here. The exceptions to that prohibition are certain agreements that can include tuition payments, discretionary bonuses, or relocation payments if they meet all 5 of these requirements that we have stated here. So first of all, the repayment terms have to be in a separate agreement from the primary employment contract. Second, the worker needs to be advised of the right to consult an attorney and be given at least 5 business days to do so before signing. Third, any repayment obligation for early separation must be prorated based on the remaining retention period up to 2 years and cannot accrue interest. Fourth, the worker must be provided the option to defer receipt of the payment until the end of the retention period without repayment obligation. And finally, repayment may only apply if the employee leaves voluntarily or is terminated for misconduct. So that's a lot, and it's tough to apply in the abstract, right? So there will be more deep dive information coming out on this new law, and if it is something that you currently do, obviously you want to pay close attention to it, and just make sure that any repayment programs that you have fall within the restrictions that will be applied here starting January 1st, 2026. If there is a violation of these provisions, the new law allows for a private right of action, and actual damages can be recovered, or up to $5,000 in penalties per worker, as well as injunctive relief and attorney's fees and costs. And ultimately, this bill, as I mentioned, I'll tell you a little bit of the background behind it. The bill, first of all, it adds 16608 to the Business and Professions Code, so that gives you a clue there. It's a kind of a follow-on to the non-compete prohibitions that have been very much in the focus of the state, as well as the feds in the prior administration, to make sure that employee mobility remains something that can happen. They don't want to restrict employees from being able to switch jobs. It also adds Section 926 to the Labor Code, and we're always nervous of things in the Labor Code because of PAGA. The industries that support, well, the industries that this bill said were kind of at issue here: nursing or healthcare, trucking, and retail. The supporters of the bill were the California Nurses Association, the Student Borrower Protection Center, the California Employment Lawyers Association, the unions, and the American Economic Liberties Project. I think it's really kind of telling, the author statement that was in the committee analyses, that this bill was sought to put an end to the practices of entrapping workers into debt agreements that discourage them from speaking out against unfair wages or unsafe working conditions. So they're actually saying they're trying to get at something even broader than this. But these are training repayment agreement provisions, which they refer to as traps, which they say lock workers into jobs and place an exit fee on them regardless of whether they are fired, laid off, or quit. So that is the actual statement from the author that was in the committee analyses. Cal Chamber said that this really is unnecessary, because if there is something that requires repayment, then Section 2802 of the Labor Code would already get at that. So regardless, we do now have this legislation. It is in the Labor Code and the Business and Professions Code. So we'll want to make sure that if you do engage in any sort of repayment provisions, that you're very careful as to how the contracts are drafted and carried out.
And one thing just to add, I just saw a question come through asking about whether this bill has passed. Every law that we're talking about today is something that has been signed and is law. The effective dates for anything we've talked about thus far is January 1st, 2026, with a few small exceptions that we'll be calling out as we go if they apply. So just to clarify that.
Yeah, good clarification. And we see some other questions as well. And if we have time, we'll get to those at the end. All right, the next bill, SB 294, the Workplace Know Your Rights Act. So this bill requires that on or before February 1st, 2026, that starting that date and annually thereafter, and at the time of any new hires, the employer provide a standalone written notice to employees describing certain workers' rights. The Labor Commissioner has to develop a template notice for this by January 1st, 2026. We'll see if the Labor Commissioner does that on time. We've been surprised with some of these requirements in recent years, but prior to that, it was very rare that we got something in enough time to allow employers to really plan ahead, but we will be watching for that. Because this bill has a couple of components, we're not going into detail of them here. If you have questions, just let us know. The second component of this bill is that by March 30th, 2026, employees have to have the opportunity to identify an emergency contact that their employer must notify if the employee is detained at work or if off-site during working hours, and if the employer has actual knowledge. Of course, the employer can't be expected to do anything if it doesn't have knowledge. A CBA waiver of this provision is permissible if set forth in clear and unambiguous terms. Penalties for violation of these provisions, $500 per employee per violation. And then for the emergency contact provision, the specific penalty that applies to that one is up to $500 per employee for each day that the violation occurs, up to a maximum of $10,000 per employee. And wage garnishment, this one just really layers on existing requirements that an employer's return that is required already in existing law to be provided to a levying officer on a wage garnishment must include this additional information here: the date the employer provided the judgment debtor with the earnings withholding order, the notice of the earnings withholding order, the name and title of the person who provided the order and notice, and a short description of the manner in which the order and notice were provided. So for any of your folks who are responsible for responding to wage garnishment orders, you need to be aware of these new requirements.
All right, a few quick changes that went into effect that impact your record keeping and some civil discovery things. So first we have SB 513. This requires that personnel records relating to an employee's performance include education and training records. It's the first change we've seen in a while to what should be included in personnel records, and that will impact when you are responding to personnel record requests. So it's something to keep in mind there. What they're looking to see those records contain is listed on the slide here, but it includes employee name and the resulting certification or qualification. Those are things we commonly see on training records. Some of the other content here, though, is maybe less innately included. So things you'll want to keep in mind of are to include the training provider name, the duration and date of the training. Obviously, that's something that we would want to see for certain categories of training anyway, such as sexual harassment. But for other trainings, maybe, again, less of a given. And the core competencies of the training, including skills and equipment or software. So again, something to keep in mind. Most relevant is going to be when you're getting records requests that you're going to want to be including these types of documents in the slate of documents for production. We also have SB 66, which removes the January 1st, 2027 sunset date that previously existed for the initial disclosure requirements in civil actions. We now have that as an indefinite requirement in civil litigation. So again, something to keep in mind as you are going through litigation in your cases. And now we're going to move on to a few of the key industry specific laws that were passed this year. The first ones we're going to cover deal with meal and rest period exemptions. So first we have SB 693. This deals with expanding the categories of employees that are exempt from California's meal period requirements to now include employees of a water corporation. And you see on the slide here how water corporation is defined. This might feel like a really small change, but any kind of expansion of these exemptions is worth noting, particularly given the employee-friendly slant that California employment law has. So that's something noteworthy there, as is AB 751, which extends rest period exemptions to safety-sensitive positions at petroleum facilities. Previously, the industries that were included in rest period exemptions were employees of an electrical company, gas corporation, or a local publicly owned electric utility. So again, some additional expansions there is noteworthy. It also confirms that the exemption applies to employees who hold a safety sensitive position at a refinery that produces fuel through alternative feedstock. Those are kind of meal and rest period pieces this year. Again, not a ton there for wide application, but worth noting. Our next one that's industry specific and really going to wrap up the industry specific section for today deals with this independent contractor and employee vehicle business expenses. And this is SB 809. This bill was intended to promote compliance with the state's ABC test, which is the independent contractor test, in the construction trucking industry specifically. So it does a few different things in that vein. It creates the construction trucking, excuse me, employee amnesty program, which serves to relieve eligible construction contractors of liability for statutory or civil penalties associated with misclassification. It also establishes a two-check system to compensate construction drivers. Excuse me. And it does a few other things, again, all with this overarching goal in mind. You'll see on the slide here, we talk about vehicle ownership. So it confirms that a person's ownership of a personal or a commercial vehicle that they're using to provide labor or services for pay does not necessarily make that person an independent contractor. And it establishes this duty to indemnify employees for necessary business expenses. We see that word necessary in regard to business expense reimbursement in other places in California law as well. Here it's being used to talk about those expenses or losses when an employee uses their own vehicle for work. And again, this is really industry specific. It applies to construction, trucking, and commercial motor vehicle drivers who own the truck, tractor, trailer, other commercial vehicle that they're using for work. And as with other expense reimbursement laws in California, the reimbursement amount here could either be a flat rate reimbursement or it could be a mileage-based reimbursement. And the intent is that whatever amount you settle on, whatever measure or method you settle on, should be negotiated between the worker and the employer, or between the union and the employer. The construction trucking employee amnesty program is similar to other amnesty programs that exist in other industries, such as motor carrier. And it's, as I said, been established under this law to relieve an eligible constructor of liability for statutory or civil penalties associated with misclassification. So that's going to do it for our industry specific laws. We're going to turn now to take a look at some of the most notable vetoed or failed bills this year. And this is worth spending some time on, because there are some that we definitely expect we'll see again in some form of another.
Yes. So this is always my favorite part of bill signing season, especially ever since Governor Schwarzenegger and then Governor Brown, who had always entertaining veto messages, sometimes with hidden code in the first letter of every line. But even if they're not, entertaining or creatively written, they're always super, super informative, especially because a lot of the bills will come back again. We're, entering the second year of a 2-year session, so it's entirely possible they may be reintroduced or maybe, entered into another, 2-year bill that's still ongoing. They also show where the legislature is thinking. The legislature saw fit to pass these all the way to the governor, and then it tells us what the governor was thinking and why he chose to veto some of these bills. The first one, the automated decision systems bill, I encourage you to read our blog that we posted on our CalPEX blog, because we have quite a bit of information about SB7 as well as the other AI bills that went through the process this session, which were more than a few. No, and I mean, everybody knows this is a huge topic right now. What SB7 would have done is it would have required employers who use artificial intelligence automated decision systems to employment employment-related decisions, such as, hiring, to provide pre-use and post-use written notice of that use to all workers directly or indirectly affected by the automated decision system. Super simplified summary of what that bill would do. The governor vetoed it, citing various reasons for it, but one of the reasons was that he wanted to assess the efficacy of the forthcoming California Privacy Protection Agency regulations to address the concerns that this bill was seeking to address. So again, we recommend you go to our blog where we have links to also those regulations and our summary of those regulations if you want to do a deep dive into knowing what is coming this year on this topic that has already been passed into law through regulation, but that might not be coming, at least through this legislation, this year. The second one I want to talk about is AB 1136. And again, all 5 of these and more are on our blog with detail about what these proposed bills would have done if signed into law, and with a link to the various veto messages. But AB 1136 was another pretty significant one, and the governor had a pretty lengthy veto message on this one. This bill would have required employers with more than 25 employees, upon an employee's request, to provide up to 5 unpaid days per year to attend meetings in which they are required to be present related to their immigration status, work authorization, visa status, or any other immigration matter. Again, just kind of one small part of that bill, but a key part there. Here, the governor said in his veto message that he really felt like this was an important purpose, but encouraged the author to take, as he put it, a more surgical approach to protecting workers and our economy, which are now under attack by the federal government, he said. And in the meantime, he specifically directed through the veto message the Department of Industrial Relations, the Labor Commissioner's Office, Cal OSHA, and the Civil Rights Department to aggressively fulfill their commitment to protect all California workers, regardless of immigration status, against all labor or civil rights violations, and encourage those agencies to work with community partners. So he, was really supporting the purposes behind this law, but felt like it didn't go about it in the right way. And his statement that he encourages a more surgical approach signals that we're going to see this legislation come back in the future, but in probably slightly different form or parsed out. AB 1326, the right to wear a mask. There, the governor said people can already wear masks if they want to, and by enacting legislation that contained what this legislation did, he felt like it would actually add more confusion rather than clearing things up. So that's why he vetoed that one. So again, I know I've plugged our blog ad nauseum, but if you like to nerd out on reading veto messages like I do, we have the links to them there, as well as a whole lot more explanation and some links to deep dives into many of the new laws, as well as some of the vetoed laws that, or vetoed would have been laws that we've talked about today. So with that, oh, go ahead, Kathy.
I just had seen a question of someone asking for the link to the blog. So for those of you who are not familiar with that resource, it's calpeculiarities.com. We cover all things that are peculiar to California from a local level to a state level. So definitely check it out if it's a resource you haven't explored before.
Yeah, and we do also have our CalPEX book that we put out every year that is a Bible that we even use. So if you would like a link to that, we can provide that to you also. So on the next slide, as Andrew previewed for you, is the CLE code. You can scan the QR code here and then just type in the title, the date you attended, and the attendance verification code. So you'll need to type in California Employment Legislative Update or something to that effect. Date viewed today, October 15th. I can't believe it. They already have Christmas stuff in the stores, even though it's only October 15th. And the attendance verification code is SS, as in Seyfarth Shaw, 0447. That is SS 0447. We'll leave this up for a minute or two, and while we do, we can start tackling a couple of the questions. I did see a couple on the stay or pay law. One was about immigration related fees. For example, H-1B sponsorship fees an employer pays and has a policy that fees can be recouped if they voluntarily leave. The definition of penalty, fee, or cost in the Business and Professions Code 16608 that has been added by this bill is defined as including, but not limited to, a replacement hire fee, retraining fee, replacement fee, quit fee, reimbursement for immigration or visa related costs, liquidated damages, lost goodwill, and lost profit. So yes, reimbursement for immigration or visa related costs could be included in the prohibitions covered by this bill. Like we said, there are some exceptions, and there can be additional exceptions essentially made if you enter into a separate contract. So again, for every category of something you think or hope might not be included within this, or a fear that it might be covered, take a look or contact your favorite Seyfarth attorney to take a look at the specific provisions of the bill to see if you can contract around it and still comply with the law. The next question kind of piggybacks on to that point, the sign-on bonus. So there is also an inclusion within the statute or the new statute for that sort of thing, but that is where there are clearly specific provisions that you can do that if you have a separate contract that clearly includes specific components. So again, it would be covered with the prohibition, but you can sort of contract around it if you follow the specific provisions in the new law. Kathy, did you have something to add on either of those points?
Not on either of those. I
Okay.
saw a question I was going to address about AB 406, which I can
Perfect. Go for it.
So I saw a question come through about is there any parameters around the total amount of sick leave that can be used for AB 406 covered reasons, the new covered reason being this leave when an employee or family member are a victim of a certain crime. And neither these amendments or the amendments last year placed any caps on the what we would consider to be safe time reasons that employees can use paid sick leave. So the only caps that are in place when it comes to sick leave are the annual usage cap and accrual caps and carryover caps that are included within the specific paid sick leave law for the state. And those are, for anyone who needs a refresher, 40 hours you can cap it to for annual usage. Carryover and accrual should both be capped at 80 hours or 10 days, whichever is greater. So all of those provisions are unchanged in the sick leave law and don't impact the amount of covered leave that anyone can use for these safe time reasons, including the additional reason for use added this year.
And Kathy, we had a question about the designated person. I think that you answered privately, but it might be useful for you to share it with the group as well, as to the effective date for a designated person as a covered family member.
Yes, so I had made a note that most of these laws go into effect January 1st of 2026. The paid family leave designated person is one of those exceptions, as we noted on the slide here. That is not effective until July 1st, 2028. So you do have a good runway to ensure compliance with that new requirement.
Okay, and I know we have a question here about whether any agency has provided a template CalWARN notice, and I will tell you, I should know the answer to that off the top of my head. I just don't remember right now, so we can get back to you on that point. Yes, we will be sending out the slides after the presentation. Many of you have asked that, as well as a recording of the presentation. And again, don't forget to attend the handbook presentation, which will again get into even more practical deep dives about this. Kathy, do you see any others? I know there's still some coming up.
For anyone whose questions we haven't answered, we will see all of those after, and we'll do our best to provide responses as well. I wasn't seeing any that we could kind of provide quick responses to right now. But we will definitely take a look at those and provide responses.
Yes, and here's our contact information. Feel free to reach out to either of us directly. Like Kathy said, happy to connect with you all, and we really appreciate you all attending and for your great questions as well.